today's web conference. Welcome, everyone. This is David Lee, and welcome to today's new app webinar, VAWA Confidentiality, Understanding the 3 Safeguards and Discovery Limitations that Apply in Cases of Immigrant Survivors in Family and Criminal Courts. Today's webinar is presented by the U.S. Department of Justice Office of Violence Against Women in partnership with the National Immigrant Women's Advocacy Project, NUAP, EQUIDOS, and the California Coalition Against Sexual Assault. That is CalCASA. It is a pleasure to have all of you with us. This project was supported by grant number 2013-TAAX-K009, awarded by the Office of Violence Against Women, U.S. Department of Justice. The opinions, findings, conclusions, and recommendations expressed in this program are those of the authors and not necessarily reflect those views of the Department of Justice Office on Violence Against Women. I do want to talk briefly about how to use this technology. Many of you have been on web conferences before with NUAP or other web conferences. One of the ways we will be asking questions of you is we will ask you to raise your hand. So if you look above my picture on the far left-hand corner and see a little hand that says My Status, go ahead and raise your hand. And we'd like to have as many people raising their hands as possible. Please do this. There will be times we'll be asking about your experiences and would like to be able to have you go ahead and raise your hand in doing that. And I see that I've got 37 of you. And when you click it again, then you lower your hand. What I'm going to do is now lower everyone's hands. There is a text chat that actually does appear on the right-hand side of your screen. To type a message, you would type there, and then you click on this 0. We have a whole host of information. People have been writing what they're in. We will be asking the questions of you. Please use the text chat to write your questions. We will do our best to answer the questions, if not at the time, later on. If we are unable to answer a question, we will be answer that, and that will be put onto the NUAP's website, where we'll have unanswered questions and other questions that will be posted for information later on. Similarly, the copies of the PowerPoint slides are available now, and I believe that Rocio is probably going to post that right this second and let you know where you can get all of the links for the slides and for other materials that we have here. And thank you, Rocio, who just did post the piece there. And then you are on the phone. If you are on the phone, your lines are muted. You can communicate by doing the text chat with us. If you need some help, send a private text chat. You just click on this private tab and you can click my name and I'll be able to support you. Or you can call iLink Technical Support if you're having trouble getting on the web conference at 800-799-4510. That is 800-799-4510. So with that, I am really pleased to be able to introduce today's speakers. And we are joined, as we are in all of our NUAP web conferences, by Leslie Orloff, who is the director of the National Immigrant Women's Advocacy Project over at the American University Washington College of Law. Hi, Leslie.
Hello. Good afternoon. Thank you for joining all of us.
Great. Well, it's a pleasure to have you. And we also are joined by Jane Anderson, who's the attorney advisor for EQUIDOS, the Prosecutors Resource Center on Violence Against Women. Hi, Jane.
Good afternoon, or good morning, still from the West Coast.
Yes, it is afternoon for Leslie and morning for you and myself. And we are also joined by Amy Cusinella, and she's with the U.S. Department of Homeland Security. Hi, Amy.
Hi, good afternoon, everyone.
Pleasure, and thank you for joining us. And I'm really pleased to be able to have all of you for today's web conference on such an important topic. So, Leslie, why don't you take the next slide.
Okay, so these are our resources. Hold on a second. So basically what we're at this Go link, you'll be able to access this webinar's, the recording of the webinar slides. We're going to have information about the legislative and regulatory history of the VAWA confidentiality provisions. We'll have a newsletter that we've just published on VAWA Confidentiality that links you to all kinds of tools and tips and resources. We have a bench card for family court judges, and we have a handout, a brochure that summarizes VAWA confidentiality protections that will be a good way to orient people towards this issue. Also, we invite you to visit our web library where you can find all kinds of information, not only about VAWA confidentiality, but all of the various VAWA immigration provisions and issues that arise for immigrant victims in family court. We also have materials there if you're doing work with judges. We have state Justice Institute funded information available, and we have Bureau of Justice Assistance and OVW information available for law enforcement and prosecutors.
Thank you, Leslie. So let's get a little bit about now ask a question of our audience. Let's see who you all are. So can you check the box in the lower left-hand corner? You're going to see a box A, B, C, or D. Let us know. Are you a victim advocate or a lawyer? As A. B, are you a prosecutor? C, are you law enforcement? D, are you a judge or court staff? And so go ahead and vote. And we're trying to get the sense of who is in the audience. And Leslie, I'm looking at the results. Why don't I start sharing the results so people can see? We are overwhelmingly 98% victim advocates and lawyers. So, and then people are writing in there, not in the text chat. Try to do it in the left-hand corner in the feedback box, so we can do that. So we have just a few prosecutors and just one. And we have some and judges and court staff, very few. But we have victim advocates and lawyers. So, Leslie, really interesting to see who's in our audience. If you're another, go ahead and write in the box in the text chat if you're not one of those, who else you might be if you do not fit in any of those four categories. Most people
anybody else who's not a victim advocate, prosecutor, law enforcement, or court?
We have a victim advocate and legal aid, whereas 15 degrees in me. And also a national TA provider on confidentiality. And great, and thank you. A practicing attorney, I think you would fit under the attorney piece, but because we were sort of looking at for both, so I wish we had 5 categories. So Leslie, I think we got a sense of who our audience is today. So why don't I, with that, I'm going to pass the podium over for the learning objectives, which is me. And so by the end of this webinar, you'll be better able to address VAWA confidentiality issues in state, family, and criminal court cases, understand the Department of Homeland Security's, that's DHS, we'll be using that acronym, policies on VAWA confidentiality and the relationship to DHS priorities, and to be able to implement strategies that will prevent or limit disclosure in state courts. So I want to have another question that I'm going to ask. I'm going to change my thing to a yes-no question. And have you used VAWA confidentiality provisions to protect survivors you work with? So let's find out from you in the audience, how many of you have used VAWA confidentiality provisions to protect survivors you work with? And Leslie, I think I'm actually sharing this live. We can see that over half of our audience has done that.
Fantastic. And those of you, again, when we ask yes/no questions, if you see, or any of the questions, the feedback box is on the bottom left-hand side. So rather than type it in the chat, click on the bottom left-hand side and we'll be able to share results directly.
Okay. I'm going to actually withdraw that question but come up with another question, Leslie, because I think we want to also get a sense, a little bit more detail.
Right.
And let me get to the feedback here and make this a yes/no here. Have you a case in which a perpetrator sought information about a VAWA, T visa, or U visa case in a state court proceeding? So have you had the experience of a perpetrator who sought information about a VAWA, T visa, or U visa case in a state court proceeding? And so Leslie, what we're seeing in our audience is that about 17–18%, depends on how many people are voting, have had this experience, and over 80% of our audience have not had this experience, Leslie.
Well, good. That gives us an idea of kind of who's out there. And again, those of you that are typing in the text box yes and no, go to the far left on the bottom and click yes or no. That would give us more accurate results. But that gives us a picture. I mean, that's about, we get calls on VAWA confidentiality issues arising either in family court cases or in criminal court cases, 1 or 2 a month. And which is why we decided to try to have this webinar where you could hear from myself focusing on the family court issues and some of the bigger overview issues, and having Amy Cuccinella here from the Department of Homeland Security and Jane with us as a prosecutor who could really help us understand how this could or should be working out in criminal court. But before we go there, what I'd like to do is if you look in the top left-hand part of your screen, you'll see a place where you can raise your hand. And my first question to you is, how many of you who've experienced this have experienced this issue being coming up in a criminal court case? Can you raise your hands? By clicking raise your hands, we want to see how many people are experiencing it in a criminal court case.
Okay, so please just on the top corner, raise your hand. And I see, Leslie, that I've got 12, 13, 14, 15, 16. So there's looks like about 18 people have almost 10% of our audience have had that experience. Okay.
And what about any of you had this experience? The issues are coming up in an employment case, a civil employment case.
So I'm actually going to lower all the hands and go ahead and revote if you have had this happen in a civil employment case. So I've got a little fewer. I've only got one person who is raising their hand that they've had this happen of 2 now. So, or only 1. So not many, Leslie, have had this in an employment case.
That's typical of, again, what we're hearing. How many of you, okay, can you lower the hands again, David?
I will do that.
Okay, how many of you have seen these VAWA confidentiality issues arise in a family court case? Raise your hand.
Okay, and I think not much of a surprise, but many more people have had this. In fact, we are getting, this is by far the most common of the 3 that you've given, Leslie.
Correct. That's actually, yeah, that's very interesting. Well, what we're hoping is that those of you, this webinar today is going to focus on VAWA confidentiality, its history. It's going to give you some strategies that you can use in all 3 of these types of cases, but that we're going to be focusing predominantly on family court and criminal court cases, but giving you strategies that should also help in the employment context as well.
Great. We had 27 people that raised their hand there, and so that's great. So
back to you, David or Amy.
We're actually going to want to get a little more detail, Leslie, about for the family law. For those 27 of you, can you write in what type of family law case it was in the text chat, just so we can get a little bit more of a feel? So a custody case, a divorce case, and asking for cash and an apology, custody, TRO, apology, custody, divorce, and some protective orders seem to be, a lot of protective orders. Great, thank you. That gives us a really good context. So I think we're now going to pass the podium over to Amy Cuccinella from DHS, and you're going to be giving an overview about VAWA confidentiality. So Amy, you have the podium.
All right, thanks, David. When it comes to interacting with immigrant victims at the Department of Homeland Security, we have a number of goals. The first being to implement federal laws, such as the Violence Against Women and the TVPA. Another is protecting crime victims and witnesses. And this includes VAWA self-petitioners, T and U visa cases. Preventing use of DHS enforcement resources on cases that involve immigrant crime victims, and ensuring that DHS enforcement is consistent with our enforcement priorities. There are 3 prongs to VAWA confidentiality, which are non-disclosure. So unless one of the enumerated exceptions apply, which we'll get into later, DHS, DOJ, and the State Department cannot disclose VAWA information to anyone. This includes applications such as the VAWA self-petitioners, the T visa, the U visa, and the battered spouse waiver cases. The abuser provided information. DHS and DOJ and the State Department are barred from taking action against the victim based solely upon information provided by the abusers, including family members of the abusers. And the third one is the location prohibition. So enforcement locational prohibitions, we cannot exercise enforcement at certain locations without following explicit safeguards. And I believe, Leslie, you're going to cover this slide.
Yeah. So what happens is that there's three different kinds of protection. The non-disclosure protections, when somebody files for a VAWA, for VAWA self-petitioning, VAWA cancellation, suspension, a T visa or a U visa, they can't, DHS or Department of Justice, Department of State, can't release information even about the existence of the case to anyone, with the limited exceptions that Amy's going to be talking about in a little bit. So this protects it protects information about the existence of the case, but it also protects information that is contained in the case, in the federal file. In addition, and that applies, those non-disclosure provisions apply to when somebody has already filed a case. In addition, VAWA Confidentiality offers two additional forms of protection for immigrant survivors. The first one is the prohibition on abuser-provided information. So what happens there is whether or not someone is a victim of a domestic violence, sexual assault, human trafficking, or other U visa listed case, and their perpetrator tries to trigger a DHS enforcement action against that victim, the DHS is not supposed to be able to rely on perpetrator-provided information. And that you don't have to have a case filed for those prohibitions to work. The problem is that the sooner a victim files a VAWA T or U visa case, there's the immigration enforcement officers for the Department of Homeland Security, whether it's ICE or CBP, have an easier mechanism to determine that the person reporting this undocumented immigrant person who's a victim is the perpetrator. Finally, the locational provisions also protect all victims and all persons, so that you don't have to have filed a case to have the locational prohibitions, let's say the prohibition that DHS officials can't go to a protection order case and try to pick up someone in a protection order courtroom. Those apply without regard to whether or not anyone has already filed. Back to you, Amy.
Okay. I noticed a question in the chat column. I wondered if I could answer now. I thought it asked, what about asylum based on DV? Is that covered under the protection? Asylum confidentiality is actually a different part of law. So unless they've applied for asylum but also applied for VAWA, U, or T, if they've solely applied for asylum, that would be covered by 8 CFR 208.6. It is also fairly protective, but actually not as strong as this.
Amy, it's Leslie. Wouldn't it also be true, though, if they're a victim of domestic violence seeking protection order, and if they already had an asylum case, whether or not they filed a VAWA T or U, they'd get the locational protections at the meaning of any kind of enforcement at the courthouse?
I couldn't answer that.
Okay. That's my understanding. Okay.
I've never seen a case where I've never seen that play out, so I'm just not sure what the department would say in that. But
okay.
If you've seen it. Okay. All right, moving on. So this is a little more about prong 1. This requirement prohibits disclosure of any information about the existence of VAWA T or U applications or any information in the A file. So I think Leslie already said this, but even the existence of the application is protected. It helps survivors who have suffered battery or extreme cruelty, human trafficking, or any of the U visa listed crimes such as sexual assault, stalking. And the disclosure is prohibited to all persons, not just the perpetrator. The prohibition on disclosure also includes information about the existence of the application, any information contained in the application, and action taken on the application by DHS. So whether it got, approved or.
Yeah, excuse me, Amy, for 1 second. I'm hearing I'm going to mute the lines again because someone's got a beep going on and they unmuted their line. So we'll do that and ask you to unmute your phone. Just 1 second.
All guests have been muted. You can unmute your line by pressing *6.
Hi, Amy, if you can press *6 to unmute your phone.
Okay, I'm back.
You are there. Perfect. Thank you very much.
All right. More on the disclosure exceptions. It is permitted to have limited disclosure in narrow circumstances. One example is disclosure to law enforcement or national security officials where it is solely for a legitimate law enforcement or national security purpose and in a manner that protects the confidentiality of such information. And here at the department, we're actually have been working on policies that get into this exception and sort of provide what protections need to be allowed even when we do share. Judicial review, these are some more exceptions. Judicial review in a manner that protects the confidentiality of the information, benefit granting or public benefit purposes, for congressional oversight and data collection, but omitting personal identifying information. And if an adult victim waives the confidentiality, then there can also be disclosure. Moving on to the second prong, the government cannot gather and or use information provided solely by an abuser, a trafficker, a crime perpetrator, or the perpetrator's family member. They can't take adverse action against the victim, and the victim may not even have to file the immigration application to be protected. DHS cannot rely solely on information provided by the perpetrator. It must be independently corroborated by the department before acting on it. Adverse information about a victim from a prohibitive source should be treated as inherently suspect. This is from one of our new policies that came out in November of 2013. The information can only be used if it's verified, and it must complete a required form that's filed in the victim's case documenting publicly verified information. And that's both in an ICE policy from 2007 and in the more recent policy.
Leslie,
Yeah, and so in addition, in VAWA 2005, when a lot of the legislative history of these provisions of the Violence Against Women Act of Confidentiality were drafted, there was some discussion because the question is, as I think some of you have mentioned in the chat question, it's like, how do you know that, how do you verify? Where might they go that isn't based on the perpetrator to corroborate or figure out whether the information is coming solely from the perpetrator? And oftentimes what the legislative history identified were things like court records, government databases, affidavits that a law enforcement official might have. There might be previous decisions by DHS or DOJ personnel. So that the idea here is that it's not fully fruit of the poisonous tree. If in fact the information that the perpetrator provided was that the victim has 3 felony convictions for armed robbery, they could go to government databases and see that. If what the perpetrator provided is something that's not objectively something that you could, something that they can't go call him up and interview him to obtain more information and decide whether he's credible. And they can't rely on information that solely comes from him. So the corroboration is really limited to these kinds of more trustworthy databases. Amy?
All right. Some examples of what an adverse action would be in these instances is denying a victim's immigration case, initiating an enforcement action against a victim, detaining a victim, or removing or deporting a victim. Moving on to the third prong, enforcement actions are not to be taken unless the action is certified in advance through a specific process that's aimed at protecting victims. These locations where enforcement action can only be taken unless it's certified in advance are a shelter, rape crisis center, supervised visitation center, a family justice center, victim services programs or provider, community-based organizations, courthouse, in connection with any of the following there, which it sounds like maybe a lot of the folks on the call work with. Protection order cases, child custody case, civil or criminal case, involving or related to domestic violence, and then sexual assault, trafficking, or stalking.
Okay, thank you. So let's ask another question of our audience. Let's get a sense of VAWA confidentiality is not violated when a DHS enforcement officer arrests a victim who has come to court for A, seeking a protection order, B, for a child custody case, C, for as a defendant in a hit-and-run case, or D, as a state witnesses in a criminal case. So on the left-hand side, please answer which one of these conditions is VAWA confidentiality not violated when a DH officer arrests a victim who comes to court for one of those cases. And Leslie and Amy, what I'm seeing is overwhelmingly, you can see that almost 98% of the people have voted C.
That is correct.
Very good. So back to you, Amy, and why don't we talk about prong 3?
Actually, that's me.
Right.
Is that me or you, Amy?
This one's me. Just
Good.
a little more about prong 3. The certification process is actually guided by INA Section 239E. If any part of the enforcement action leading to a victim being brought before an immigration judge included relying upon the abuser-provided information or enforcement action taken at a prohibited location. So if it's relied on either prong 2 or prong 3 that we've been discussing, they need to complete a certification process. And we, at the Department of Homeland Security, it's required to file the certification in the immigration case that VAWA confidentiality protections were not violated. So if you're going to go ahead and proceed with an enforcement action at a sensitive location, or you are going to rely or corroborate information from an abuser, you have to certify that you didn't violate any of the provisions. And Leslie, I think this one's you.
Okay. So in addition to that, there are some additional protections in terms of locations. So you saw the list in terms of courthouses in connection with certain kinds of cases, domestic violence, sexual assault types of programs, family justice centers, etc. But in addition, there are other DHS policies regarding other locations where DHS enforcement actions are not supposed to take place. Now, what's important to understand about all these is that they're constantly evolving. So, as you can see, you've seen policies from 2013, policies from 2008, 2007. One of the things that we keep up to date on our web library is whenever we learn about new policies issued, we get copies and put them on our website. We also link to the DHS website where they're located. So it's important to kind of stay abreast. If you're working on a case like this, give us a call and we'll make sure you have the most up-to-date information, or check out our website and we can do the same. So other prohibited locations include places like schools, places of worship, funerals, and other religious ceremonies. And in terms of immigration enforcement, there's this expectation that ICE and CBP will proceed cautiously for any kind of arrest at a sensitive location. There's been a new policy implemented in the last 6 months, a little less than 6 months, by Immigration and Customs Enforcement, in which they've agreed that they will only do courthouse-based enforcement after a particular target individual that is a high priority for immigration enforcement, and that they won't ask questions of other individuals, that like a friend or family member that might be accompanying that individual to court, that they're generally going to be in courthouses in plain clothes, and if they are stopping an individual at a courthouse that's one of these high priority targets, they are going to try as much as possible to do that not in a public space, so that they don't scare away other people from seeking help at courthouses. Back to you, Amy? Or?
Yeah. All right, one of the questions we hear a fair amount is, when does this protection end? So when the limitation to disclosure ends when application for relief is denied based on substantive grounds and all opportunities for appeals have been exhausted. And
now I'm going to go back to you, Leslie.
Okay. Great. So there's a number, we've been alluding to them, but there are a number of VAWA confidentiality policies. There's the all DHS policy that Amy referred to earlier. There's a public policy that is available from Immigration and Customs Enforcement about the rules that they have. The policies for U.S. citizenship and immigration services that have been around for a long time. They first came out in 1997. Those may be updated at some point. And there's also policies that were issued by the Executive Office of Immigration Review that control VAWA confidentiality in the context of immigration cases, and those came out in 1997. Amy, I think this is you again, or is it me?
I believe it is you, Leslie.
Me, okay. So that the other thing I want to talk about is that, I think I mentioned it earlier, DHS has developed a computerized red flag system called the 384 system, in which when somebody files a VAWA, T, or a U visa case, the case is red flagged so that any immigration enforcement official or anybody who's working at USCIS can immediately see from their computer systems that this is a VAWA confidentiality protected case. It doesn't disclose whether it's a domestic violence victim, a sexual assault victim, or a human trafficking victim, or a U visa victim. It doesn't say what kind of case. But it basically reminds enforcement officials that this is a case where they shouldn't be relying on perpetrator-provided information, and it helps them, I guess you could say, not be tricked by perpetrators into trying to pick up or detain or harm the victim or take evidence from the perpetrator and use it against the victim in any case. And what I think is really important, since particularly with so many advocates and attorneys on the phone, is that this system, to a certain extent, really changes safety planning that we do in a lot of ways. So that if you have a choice about whether to file a protection order first or a custody case first or the immigration case first, if you file the immigration case first, what will happen is the victim will be in this red flag system. So if the perpetrator, in retaliation after being served with the protection order or the custody case, tries to get her removed by calling DHS to turn her in, this will help make sure they don't react to his phone call. So it's really important. It's really, I think, one of the really important pieces of the puzzle in terms of victim safety of the various things that the Department of Homeland Security has put into place.
Yeah, Leslie, I would add also CBP and ICE. We put it in a database that CBP and ICE regularly check. So it's not just flagged for USCIS, but the actual enforcement arms of the department should be seeing that, which is really helpful.
Right. And it also means that what happens is if in fact you have a case where a DHS official shows up at your at the courtroom in a protection order case, or shows up at a shelter, or shows up at your victim services agency looking for the victim. If you can go to our website or the CIS website, DHS website, download these policies and hand them to them. And victims have been very successful. Victim advocates and attorneys have been very successful in helping, and that's why having a lot of these policies publicly available is important, because it helps do the frontline advocacy to educate officers in the field that may not know about these policies, that they exist. The other thing is that the All DHS policy required that everybody get training on this through a very good video that was developed by the Blue Campaign. And so hopefully that should be, we actually did some research last summer among Border Patrol, and we found that the proportion of times that Border Patrol had been reported to be violating VAWA confidentiality dropped precipitously after the training. So it's really making a difference.
Okay, this is me. VAWA confidentiality includes penalty provisions or violations. For each violation, the perpetrator or the person who violated the law could be subject to disciplinary action and or a $5,000 fine per violation, actually. And the violation could include making a false certification in the notice to appear. So the certification that we talked about earlier that's required before taking certain action, if, say, an official were to falsify that could also be considered a violation. The department does have guidance on where you should file complaints if VAWA confidentiality is violated by a Department of Homeland Security employee or officer, and that's actually my office, the Office for Civil Rights and Civil Liberties. We have that information on our website for how to file a complaint, and I'm sure Leslie can probably get you the link too if you ever needed it.
Yeah, Rocio, can you post it? Rocio will be posting it in a moment in the chat box.
Okay, great.
Okay. So the last thing I think we want to mention in terms of VAWA confidentiality has to do with the effect that violation of VAWA confidentiality could have on an immigration proceeding brought against a non-citizen. So if in fact the perpetrator is successful in getting or contributing to the initiation of an immigration case against the victim, either because she was picked up in a protected location or because in some other way DHS relied on perpetrator-provided information. The legislative history of the Violence Against Women Act of 2005, which was bipartisan and written by Sensenbrenner and Conyers, makes it clear that the immigration judge has the authority under those circumstances to dismiss the immigration proceeding for violation of VAWA confidentiality. So there's, in addition to the fines that Amy was talking about, if in fact the victim ends up in proceedings, there's another kind of check and balance there and another remedy that could be available to help her. If whenever a proceeding is filed, DHS is required to certify before the immigration judge that VAWA confidentiality wasn't violated, or if they used any of the information or did an arrest at a courthouse or something like that, they have to show that, they have to certify that they didn't rely on perpetrator-provided information to do that. So this is another part of the remedy. Okay, so at this point we're going to move briefly into, I'm going to go over some of the some issues regarding family court cases, at least initially. And so why is VAWA confidentiality important for state courts? And it's important to raise to both state courts and state court judges that what VAWA confidentiality tries to do and how it can be used in both civil and criminal courts is a way to make sure that there are just and fair outcomes in state courts, and that the perpetrator isn't able to use the state courts, or to limit the ability of the perpetrator to use the state courts through discovery, family court discovery in particular, as a way to kind of circumvent the protections that Amy just discussed that are afforded by the Department of Homeland Security, Department of Justice, Department of State. So perpetrators can't get the information about her case from DHS. So some perpetrators try to get it through the courts, and that becomes, there are a series of federal district court cases that address, particularly, there's 2 family court cases and 1 criminal court case. What I'm going to do now is, for the next few slides, discuss what the federal district court cases have found when a perpetrator who a judge denied discovery in a family court case went to federal court to try to force the Department of Homeland Security to turn over the information. That's how these federal court cases were initiated. And so, first of all, I'll say that the only criminal court case in a federal district court to address this issue was a case in New York. It is because of VAWA confidentiality and unpublished opinion, not even, you can't find it anywhere. It's under seal. But what the court did in that case, and Jane will be talking about more of this as we go forward in the next section, but what the court did in that case is the perpetrator argued that because argued that they should be able to obtain the information as discovery in a criminal court case, and the federal district court denied the request and ordered that the information not be turned over from it was a VAWA self-petitioning case. In Hawke versus the Department of Homeland Security, which is the first federal district court case to address these issues, the court basically said, and it's similar to the policies Amy discussed, is that the protections of VAWA confidentiality continue to apply to the case forever unless the case is denied on its merits. So in this Hawke case, it was a case in which a victim obtained lawful permanent residency after filing a VAWA self-petition through another avenue. And the court ruled that VAWA confidentiality protections didn't end even though the VAWA case was dismissed because she no longer needed to get legal protection under VAWA. It also clarified that judicial review of a determination means an immigration judge, not civil and criminal court proceedings, so that people are trying to use this judicial exception to the code to say then state courts could give it to me if the Department of Homeland Security wouldn't. And Hawke said that wasn't true, that what the statute meant was judicial review of the victim's immigration case. Additionally, Hawke directly addressed the point of whether there was a Sixth Amendment right to compulsory process would permit access to the information, and they said no, that if in fact the material is privileged, that the Sixth Amendment right it doesn't trump the privilege. And they basically said that to rule otherwise, the primary purposes of VAWA confidentiality provision, namely to prohibit disclosure of confidential application materials to the abuser, couldn't be accomplished. And then the more recent case was a Connecticut federal district court case called Demaj versus Sakaj, I guess. And in that case, they said that there would be no disclosure of privileged information to alleged perpetrators, and that the goal of this statute was to stop the interference with the victim's immigration case, and the court concluded that efforts to obtain information through the custody case constituted the kind of interference with the victim's immigration case that was barred by federal statute. And they also went one step further to say, how do I do this, David? That, let's see if I got it right. Yes. This is another important part of this case in which they actually said that even where a victim discloses that she received a U visa or VAWA or VAWA self-petition was approved, that she's actually here lawfully as part of her civil case, that doesn't open it up for full disclosure of everything contained for a fishing expedition to essentially find out what's in the victim's immigration case, because she disclosed the fact that she has legal status now. And so best practices for VAWA confidentiality in family court cases is to, one, identify whether this might get raised in your family court case as early as possible so you can be prepared. And we'll be talking at the end after Jane makes her presentation about motions in limine and Rule 11 motions and things like that. But also just keeping, objecting to relevance, identifying the fact that the perpetrator could elicit the information in other ways are really important. And these issues come up in not only in family court case, but in employment cases brought by employers involving sexual violence and other sexual harassment and other instances in the workplace. And that in those cases, the legislative history provisions could potentially be useful in trying to impede the employer from obtaining that information in the civil court cases. The problem there becomes how closely aligned the employer is with the perpetrator. So if the employer is the perpetrator, then the argument against discovery of it in the civil case is much stronger. This is an evolving area that we're going to be doing more work on in the future. And I think that a lot of what Jane is going to be talking about next in the criminal court may be instructive not only in the family cases, but on the employment cases as well. So I'm going to turn the podium over to Jane.
Thank you, Leslie. Hi, this is Jane Anderson. Thank you for allowing me to partner with NUAP here. I'm with Equitas, which is the Prosecutor's Resource on Violence Against Women, and a former prosecutor myself in Miami-Dade County. I saw a couple of people were from Miami. I hope you're enjoying the weather. And I spent quite a bit of time in our misdemeanor domestic violence unit in Miami, and as you may imagine, these issues came up quite a lot. So let me go forward here. I think we might have asked something similar, David, at the beginning, but you want to ask this again?
Let's ask this again. Have you been there's a little different. Have you been involved in a criminal case where discovery attempts were made to obtain information in a U visa case? So go ahead and in the box, just let us know if you've been involved in a criminal case where discovery attempts were made to obtain information in a U visa case. And Jane, we can see about 13% of our audience say that they have experienced this.
David, can you show us the box?
Oh, I'm sorry. I forgot to share. Now I'm saying, now it's 16% have had experienced this.
Okay. And what types of criminal court cases were these?
So go ahead and write in the text chat, which appears on your right-hand side of the screen, what type of criminal court cases were these? We asked earlier about civil, so a restraining order violation. What other types of criminal court cases did you have where you saw this happen? Assault, family violence, DV, sexual assault, murder, sexual assault, domestic violence, sexual assault, child sexual abuse, domestic violence. So we see DV. There was actually a question about it, which is not a criminal court case, but an annulment hearing on the civil side. Someone is asking domestic violence. So I see a lot of DV sexual assault cases, shoplifting, and then a battery case also. So Jane, interesting as we see where these all go.
And it makes sense because, that's the allegation that they're likely asserting in order to self-petition for the U visa. So discovery obligations in criminal court. We have here a bit of a three-step analysis that might be helpful. The first is it relevant or material? That's defined by the courts as, does this information tend to prove or disprove any fact significant to the issue at hand? Now, U visas, the certification, the application is going to have information where the victim has likely asserted that he was the victim of some sort of violence. And if that is the case, the same case that's in court, you're going to have a really hard time saying that this may not obtain something relevant and material. Brady or Giglio, is it evidence that tends to exonerate the defendant or calls the victim's motives into question? Again, that's going to be something very hard for a judge to say, no, it doesn't. And then the third one, is it in the state's possession? And that's where we're going to have some differentials between what are we actually talking about. So let's move forward. So the things that most likely are going to be asked for in discovery are going to be the U visa application, the law enforcement certification, any supporting documentation that the victim provided along with their application. They may ask for the name and access to the victim's immigration attorney, and also if she received any services as part of that. So two of the things I want to talk about is sort of this idea of, do these things exist, and whether the defense counsel has a right to know, yes, these things exist, versus does the defense attorney have the right to have the entire content of, let's say, the VAWA file that's in the hands of DHS. So there's strategies to protect the victim. The number one thing is you need to be coordinating with everybody that's involved. And we always like to make sure that there's as much coordination going on as possible. And this is going to include in cases involving VAWA confidentiality and U visas, the prosecutor working with the immigration attorneys, a legal aid attorney, any victim services that are providing, whether they be from an immigration stance or whether it just be based on the victim's trauma. That coordination is going to be key to protect the victim. The other thing that I think is important is to educate the judge, because judges are often going to err on the side of the defense, sort of this open folder policy of discovery. And I don't think, if you don't properly sort of give the judge the background of why these things exist, why the U visa was started, what are the ideas behind its confidentiality. If you really lay out for the judge some of those foundational arguments, which Leslie covered at the beginning of this presentation, I think it gives the judge something to hang the hat on as to why they wouldn't order discovery of some of these things. Another thing I would encourage is that to concede that these things exist. And I think when you concede the existence, number one, the argument is legally you're doing the right thing, but you're also going to lend credibility to your argument, and you're always going to be out ahead of the game. But you want to also try to limit the disclosure of the content, because that's really where the confidentiality lies. These should be argued in pretrial motions, and these things should be decided before ever starting a trial. The worst thing to do is in the middle of a trial, in the middle of a victim being on the stand, that these issues come up. So always argue these in pretrial motions. Prepare your victim for the cross-examination that it inevitably will come up. And, the rules of cross-examination are broad. Defense attorneys have the right to examine any bias, any motives, and it's going to be a hard argument to say that the fact that she or he had filed for some sort of immigration relief based on the allegations of the case, that's not going to be something that they can go for. So you just need to make sure the limits of that are laid out ahead of the time. We do that with our pretrial motions, and that the victim's prepared for those questions when they in fact do testify. And then, of course, if appropriate, you may want to consider using expert or fact witnesses, and we'll go into that a little bit. So this is just talking about the coordination between all the different people and how that really is going to lead to your success in these criminal cases, and as well as just having your victim feel protected and prepared for the process. The U visa application can be made any time after the criminal act. There is no statute of limitations. So that's one of the things that when you're coordinating, when you're speaking with all the partners, something that an attorney may want to, an immigration attorney or a victim rights attorney may want to be aware of, that application does not need to be made at any time. And that the initial application actually requires very little information. And that the supporting documentation that's required for that initial application is likely the public record, the law, the police reports that the defense counsel would already get in discovery. So this is just sort of making sure everyone knows, like, we could do something fairly bare bones for the visa application, and that may be a strategy that you would want to discuss together and make a decision about. And then the certification can be completed by the prosecutor, by law enforcement, by a judge, and by other deemed people. So educating the judge, you want to provide that context we talked about, that it really is to promote the reporting, investigating, and prosecuting of violent crime. That's why we have those protections. We're trying to encourage, especially women and victims that are coming from vulnerable populations where these things can be regularly exploited, their immigration status. And we're trying to get the most vulnerable people to be able to escape abuse and violence. And we're trying to prosecute those that are exploiting the most vulnerable people. And that's the context of why we have these things. So you really need to make sure that the judge gets that. Because when the judge starts hearing things like vulnerable victims, perpetrators that are preying on vulnerable victims, that kind of are some magic words that a judge may thank you for giving them a reason to help you with your disclosure. And then you also want to remind the judge that these are very strict confidentiality protections that are statutorily made, and that they really shouldn't be taking this lightly, which is something that I found in my practice was done fairly regularly. So this is a disclosure requirement that does not extend to information acquired by federal agencies uninvolved in the state's investigation or trial. So, there's this discovery idea that anything that's in the state or the government control, that knowledge and that possession is imbued upon the prosecutor. But this limits it in cases where different agencies have information that's not related at all to the investigation. And the argument here would be that once immigration proceedings is not related to the criminal court. But we do need to make concessions because judges are going to be faced with a balancing act. And I think, there's this overwhelming concern that defendants be protected. And I know that in my practice, it was often something that, victims would be like, what about me? Why am I don't have any protection. And of course, that is sort of how how it's put out here in criminal cases. The defendant does have more protection. And so you really can foster some credibility with your judge if you make some concessions. Because this defendant is facing potential incarceration, deprivation of liberty. They have a right to confront. They have a right to explore bias and motive. And on the victim side, you have her privacy and her security. And a judge, I think, when a tie goes to the runner, well, the tie's going to go to the defendant. And, that's where judges are appealed. They want to protect their record. And so you're going to often find that judges are going to err on that side. So one of the ways to go about and address this is to concede some things, including the existence of a U visa application, the existence of a certification, and accompanying documentation. Okay, so what are we talking about? We're talking about the application of certification, victim statements that are made as part of either of those, supporting documentation, and the actual DHS file itself. And these can be sought either through discovery pleading, and this is how it can also be disclosed. So you may just file a discovery pleading that says, on such and such date, the victim, file an application, or on such and such date, the certification was signed. Also, you could disclose this via a Brady notice, a discovery exhibit attaching copies of such things. You could disclose any witnesses that were a party or had information. And you can also ask that things that you don't believe should be disclosed in full be reviewed in camera prior to disclosure. Okay. So disclose. What to disclose? Disclose the fact that the victim applied. Disclose a completed certification. Advise the defense attorney of any witnesses that may have relevant or material information regarding that application. And advise of any supporting documentation in the state's possession. Most likely the supporting documentation, like I said, would have been turned over in discovery proceedings anyway. But you do want to...
Jane, this is Leslie. Can I add something here?
Sure.
So this is where, for attorneys and advocates, it becomes really important. So if you think about it, of what is Jane going to have in her possession as a prosecutor, right? She's going to have statements to the police, police reports, etc. She's going to have maybe a letter requesting a certification and the signed certification based on whatever evidence they had in their own records. If, however, the victim turns over, let's say, a copy of the affidavit or more detailed information in asking for the certification, Jane is also going to have that and would have to potentially turn that over. So it's really important that the request for certification be limited to essentially the 4 square corners of what the police or prosecutor might have in their own records.
Perfect. And and that's one of the things that collaboration can help with, is if those initial applications are bare bones, then there's less in my file that I may have to turn over in the end, and that's something that you want to sort of consider. And then, of course, the last thing is what do we really fight? What are we going to really fight over? And that's going to be our motions to quash, and that would be any subpoena for the file itself, and then any subpoena that defense counsel may issue to the immigration attorney, to any counselor that you may have advised has information to the process. You want to go ahead and make sure you're saving your fight for that. So what are your tools as a prosecutor? You have protective orders. You can redact the information that you have to protect privacy concerns. You can move to quash any subpoenas. You can ask for in-camera reviews and provide the judge with the law that the judge needs to have while reviewing any material, so that the judge is fully aware of the extent of confidentiality and is reviewing the materials with that in mind. You can move in limine to limit cross-examination or things going into evidence. And you can ask for expert testimony to be proffered regarding the U visa process, the application process, and to talk about how the victim was advised of the U visa opportunities. So the victim testimony, the more the victim is prepared, the less damage is going to come out on the stand. And that's just something that's a guiding point to all prosecutions in general. But in particular in this case, because we're talking about victims that have been the victims of violence, that are particularly vulnerable and probably not very trusting of the process. So you're asking this person that has all of these things already happening to take this stand in a criminal court and talk about not only the violence that they endured in the case in front of the jury, but also to sort of be susceptible to this cross-examination and these attacks on their character. So this is something that you really can't take lightly, and you have to very much prepare your victim ahead of time. That should be done with pretrial interviews, where you establish the timeline, where you review the statement, maybe a mock cross-examination, and then talk about what might come out as rebuttal. I want to go back to the establishing the timeline, because this is going to sort of prepare us for the next step. If the defense is going to say, and this is very common in my practice, the victim is alleging this assault. Let's put it in the context of sort of a misdemeanor domestic violence case where we don't have, a lot of other sort of physical evidence. Let's say there's no, huge injury. And so you really are relying on the victim's testimony for the most part, maybe a 911 call, police officers. But the defense is that the victim is making this all up because she's in this country illegally, and she knows about this U visa, and she wants to take advantage of the immigration benefits of applying for a U visa, and she's throwing this guy under the bus in order to establish that. Well, you want to establish a timeline and have this come out in court, which is when did the alleged incident happen, and when did she find out about the benefits of a U visa, and then when did she file her application, and then when is the trial. And this is going to be another piece where you really want to make sure you're collaborating, because as many of you probably know, victims of violence and abuse, and especially in intimate partner situations, they're going to have, traumatic memories, and it's going to be maybe a little bit more difficult to establish that timeline, because that's just not the way traumatic memory will sometimes work. So collaborating with your victim services is going to be key in preparing your victim for this trial. Again, rebuttal evidence. You may have to wait until, not in your case in chief, not in your direct examination, but after defense counsel has cross-examined the victim about this bias and this motive to lie, and then bring about the timeline in your rebuttal evidence. And again, the key is going to be this timeline. What is most likely going to happen, although there's a plethora of different circumstances, obviously, you're going to have a situation where the victim was the victim of the assault, called the police, and then at some point later on was put into touch with victim services. And victim services most likely advised the victim regarding the U visa, and then at some point applied for the U visa. So what this sometimes can help us with is we can actually introduce prior consistent statements. Most of the time, the victim statements to the police are not going to be able to come in at trial because they would be considered hearsay. So this is actually a kind of a tricky situation where maybe you get those statements in if you can establish this timeline. And your expert or fact witnesses regarding the U visa can be really helpful, because if you can get someone out of victim services to say, we advise everyone that comes through the door about the U visa. This is part of our initial little intake with victims. That will help the jury understand that what came first, the victim finding out about a U visa and then, sort of making up this crime as part of her scheming way to get into this country, or whether this U visa was, this information was provided to her after the fact, when she had already been a victim of the crime. So the prior consistent statement, and sorry for the attorneys out there for reversing this, but it's kind of informative to hear it again. In Florida in particular, and that's where I have the rule here, but I think it's also the federal rules of evidence, and therefore state to state, they probably have something very, very similar. A statement is not hearsay if the victim testifies and is subjected to cross-examination, and the statement is consistent with the trial testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. So that's exactly what that cross-examination is, right? The cross-examination is this implied or expressed charge that, hey, you're lying because of this U visa. So you have a motive to lie. So if the defense brings that up, then the victim will be able to testify as to prior statements, which may include the statements in the U visa application, statements to police that would not otherwise be admissible. So I like to sometimes turn this idea that they're going to use this visa against the victim and use it as a way to impeach them. It's actually, if you turn it around, you may be able to get more supporting evidence through this prior consistent statement. And again, that's the key is the timeline.
Jane, this is Leslie. Those consistent statements would be things like the police record that might not come in. It wouldn't necessarily be anything she wrote in the U visa application.
Correct. it would be anything before the U visa application, if I wasn't clear. Sorry about that. So here you actually have a couple of examples. A 911 call may or may not be admissible depending on other evidentiary issues. But let's say she gives a statement to the police at the time of the incident. That normally would not come in to court. That would not be something that the state could present, or the victim could testify to, or the police could even testify to. That would be pure hearsay. But if you can establish, and the defense charges that she has a motive to lie because of this U visa, and the motive to lie came about after that statement, then you will be able to get into evidence those prior consistent statements. And that's very powerful, because then a jury hears that she said it the night of the incident, she said it again, and she's on the stand and she's saying it now. And with or without that U visa, she's been 100% consistent. So that's a real powerful tool to sort of flip the script on defense counsel that are going to try to use this U visa application against your victim. And how about you? What did we say, David? 18% of people that had come up with criminal cases where discovery tools had been asked, or excuse me, U visas have been asked for in discovery. Anybody else have effective strategies?
Right, so let's hear from people. So go ahead and write in the text chat. We know that you have a lot of experience of all of you on the line, so we'd like to hear other strategies that you've had on being effective in protecting confidential content. So let's hear what we can be able to hear. I know Rocio has been doing a great job of answering questions that have been coming up in the text chat, but we'd love to hear from you. Are there other strategies that you have used to be effective in protecting confidential content? And I think, Jane, you're really clear and concrete in some examples about how to be able to do that. So far, I am not. This one people have to think about a little bit, Jane. You're right. It's not one way. It's a three-word answer. As you have to be sometimes creative or thoughtful as we try to protect the confidential content. And as you said, a lot of it, Jane, was making the case for the judge to be able to understand the context of what's going on and being able to present that.
I wonder if maybe what we should also ask, this is Leslie, is whether people could, if they've been successful in making arguments to judges in criminal court cases, they could raise their hand and we get a sense of what people have been trying to do. Maybe that would be a way to share.
Okay, so how many of you have been successful in protecting confidential content in a criminal case? Please raise your hand. We've got one starting. I'm sure there are more than one of you that have been successful. Now we are starting to see several people sharing that they have been successful. So not a lot within the criminal court. We've got a few people who have. We've got 5 people who've now indicated that they have. So perhaps why we're not getting a lot of answers.
Those people, I'm wondering, could you just type in where you're from, what jurisdiction, so we get a sense of what it looks like nationally? And David, can we do the same thing? Can we have people raise could you remove the hands and raise the hands about those, maybe of the people that had been seeing these issues up in family court cases? How many of you have worked with a victim or worked on a family court case where the court didn't allow discovery of the information for a U visa or a VAWA self-petitioning case? Can you raise your hands for that?
Okay. So now let's go. Have you been, so raising your hands if in the family court or in the civil family court that you've been successful in being able to keep content confidential. And I do see that Bill Tamayo did give another example here, which we might want to do. So I see once again a few people have been successful within family court.
And David, I'm going to just read what Bill said so that it'll be part of the webinar, that in Carzola and the EEOC versus Koch, the court agreed that the EEOC as a federal agency was bound by federal confidentiality rules, but said that the defendant could issue a subpoena to the private plaintiffs to get a copy of the U visa. Has anybody had this in employment cases? Maybe we should ask about any of you.
You're thinking about it. There was another question of, has anyone used the prohibition against DHS disclosing VAWA applications to prevent subpoenas to victims' attorneys and immigration counselors? Alicia is asking that question.
Okay. And so this is Leslie. We have seen a lot of that where they're trying, most of the family court cases are happening in the context of trying to subpoena the information from the victim or her attorneys or advocates, and using some of the same kinds of strategies that Jane was discussing. People in family court have been successful through using motions in limine, for using asking for in-camera review, etc. In a very similar way to what's happened. I'm going back to Jane's slide. Where is that? I shouldn't do this. All right. Using these same kinds of tools, asking for protection orders, asking that they redact. They're going to release it, redact information. But in family court cases, most of the time, the motions to quash, the protective orders, and the motions in limine, based on, and particularly with the help of the 2 federal district court published cases, has been very helpful in trying to preclude that in family court. Just to go back to Bill's question, Bill Tamayo from the EEOC's question again, because David, can we have people raise their hands? Can you clear the hands and see if any of you have run into this in employment cases where they've been subpoenaing the U visa from the private party?
So if you please raise your hand if in an employment law, if someone has been seeking to get that through by subpoenaing a private party. So raise your hand if you've experienced that situation. Right now we have not had anyone saying they did.
So it's something that I think is important for people to be aware of, and if in fact you're working on an employment case, call us and we can connect you with experts at the EEOC and also try to provide support using some of the kinds of strategies that James discussed in criminal court and that I'm going to be concluding the webinar talking about in the family court context to try to help by some of the strategies Jane was talking about and some of the court rulings that I was talking about in some of these employment as well as family court cases.
And I saw that Alicia is asking for some sites and for some of these published cases, and if we don't get the sites up in the text chat here, I recommend contacting NewApp and they would be able to provide those to you.
Yes, we actually can, part of the materials at the location, if they're not up now, that we'll put up at the link for this webinar will include a fact sheet with all the citations of all the court cases that are available. Okay. So in concluding, the next thing I want to add, before I move on actually, Jane, is there anything else you want to add based at this point on your presentation before I move on?
I don't think so. Thanks, Leslie.
Okay. Anything that you want to add based on what you've heard so far?
No, I'm good.
Okay, good. So what I'm going to do now is kind of conclude the webinar talking a little bit more about kind of 2 things. One has to do, so we've talked about a lot about discovery in the family and criminal court case, and I just wanted to take this opportunity to talk about how some of the ways that both Jane mentioned and that I think are very useful in the family court cases to plan for this and to head off some of the problems that, you know, head off and be prepared should they try to discover these issues in the family or criminal court cases. But also to talk about that if in fact any of you encounter a situation in which a DHS official is trying to based on information provided by the perpetrator, what do you do? So first of all, I really want to make a plea, and I think Jane highlighted very well in the criminal context about how it might be helpful there as well, which is the idea of filing skeletal applications early, both gets people VAWA confidentiality protection in terms of trying to get DHS not to react because they can see cases protected in the online computerized system that ICE and CBP can see, but it also sounded that this skeletal application approach may also provide some protection if there's an ongoing criminal case. In fact, a judge decides to release anything, there's not much there, at least initially. And I just want to say, Bill Tamayo, myself, and Aparna Bhattacharya were up training the Vermont Service Center at the beginning, several weeks ago in January, and we alerted them to the fact that we're encouraging people to file skeletal applications because in order to get the VAWA confidentiality protection sooner so that they can expect to see cases come in that are not as completely fleshed out in the future and have to, where victims are going to provide more information after they issue a request for further evidence. So it's important to understand that. And just for the practitioners on the phone, is if you do this approach where you're filing a skeletal application and then you get a request for further evidence, it's very important to try to respond for that request for further evidence as soon as possible and not wait for the full, I think it's 97 days you have to respond, because the sooner you, like if you respond in 30 days as opposed to 90 days, the victim's case will be adjudicated 2 months sooner, and she'll get work authorization 2 months sooner. So it's important to understand the role we play in that process. So if you file a skeletal, immediately start preparing for your full application so that you can respond as quickly as possible to the request for further evidence. In terms of, safety strategies, we also, one of the things we encourage people to do is give the survivor a copy of their receipt notice in the case so that they can show that to a government official should they be trying to stop them, and also have people memorize their A numbers. So if they're stopped by immigration enforcement officials, they should tell them their A number and tell them they have children so that they're not, they reduce the likelihood that they'll be detained. You want to be prepared in family court cases, much like Jane said, to object to discovery and cross-examination, and be prepared for cross-examination if the perpetrator is trying to discover the existence of a VAWA T or U case in the family court context. You want to provide copies of the DHS policies that are publicly available to judges as part of attached to briefs, and I posted the links to some briefs for this model briefs that we have for the civil family court cases and model briefs for the criminal court cases. And you want to actually train court personnel and agencies at prohibited locations about VAWA confidentiality. Is this better than I can, and I'm just going to reiterate, make your record, be prepared for what's going to be happening. If you're prepared and you're expecting that the perpetrator will raise this in the criminal or civil case or the employment case, then you have a better chance of being able to both object if that's what you're going to do for your case, or if any information is going to be released, you can have an informed safety planning discussion with the victim so that you can mitigate any harm to her that may occur from whatever information is going to be released. And for victims with approved cases, some of them may feel that it's okay to admit the fact that she's actually had a VAWA confidentiality case approved as part of her case in chief. So a VAWA or a U visa case approved, and it just gives you more flexibility. If not, if you ask for VAWA confidentiality protection and it's not granted, you want to be sure to create your record so that you have the opportunity to preserve your record for appeal. And that these are a summary of the kinds of things. We have the sample motions in limine that we can provide to you. We have fact sheets on Hawke, and we have copies of the various government memorandum that can be useful in litigating these cases. The last thing I want to talk about is Rule 11 sanctions. Some attorneys have been very successful and we actually have a model brief, a model motion and points and authorities on this point, in which people have won motions, particularly in the family court and civil court family court cases, under Rule 11 sanctions against a perpetrator or his counsel for trying to the U visa or VAWA files as part of the family court litigation. And that has resulted in pleading striking the motion disciplinary sanctions. That it's also very important that, and the other thing is that even in the criminal context, you might want to consider treating threats, or in the civil court context, treating threats of deportation similar to threats of criminal prosecution for Rule 11 purposes. So most importantly, and we have a few minutes, David, for questions, we want to, just to reiterate, you want to be ready for these violations to happen, for the perpetrator to try to obtain this information, be ready to advocate on the spot. If in fact it's a DHS official that is potentially violating VAWA confidentiality, you want to get their name, agency, and badge number, just like you do for police officers that your client interacts with. And know that if you have a client, we do know that perpetrators of violence, of domestic violence, sexual assault, and human trafficking are for victims with pairing VAWA and U visa applications, often try to call and get their client turned in for immigration enforcement. And if one of your clients is picked up, call the ICE hotline and inform them that she is a crime victim, and inform them that maybe she has a case that's already got VAWA confidentiality protection, and call us and we can help you as well in terms of advocacy to get her released. So I'm going to stop now. That leaves us, I think, a few minutes for questions.
Yeah, Leslie, well, one of the questions that is asked is, how do you deal with judges who already have prejudice against immigrant victims? And so while you might have that prejudice is there, and so what are some strategies? And this might not be just you, Leslie, but any of our speakers today.
I'll just start by saying I think providing information to the judge about what we've found in doing judicial training. We have a whole series of bench cards that have been funded by the State Justice Institute on these issues. And what we have found in training judges is that sometimes judges are misinformed and perpetrators play on that misinformation. So they feed information to judges that anybody who's undocumented in this country is deportable and therefore she should be denied custody. Things that are not a reality given DHS policies, guidance, regulations, etc. And so what I generally do is approach it as if the judge has misinformation, and how can I do a brief or provide them information to get the judge the proper information so they're not tricked into colluding essentially with the perpetrator unknowingly. Jane, do you have ideas on that?
I mean, I can just, reiterate the education. Unfortunately, you're going to come across judges that may have deep-seated prejudices, and hopefully you can account them, you can give them as much information as possible, and depending on, what kind of case it is. I mean, luckily my background is from the criminal side, so ultimately a jury was always going to be the ultimate arbitrator of what happened, and so that's a little bit different than maybe some of you practitioners are dealing with judges making the ultimate decision. So educate, educate, educate.
Right, and we are looking, for those of you, just to make an announcement, we have State Justice Institute funding, and we're looking for courts and judicial training. We have 2 more jurisdictions that we can take the training to. So if you are working with your court judicial training staff in your state and they would like to request a training, it can be made available to them through NUAP with our judicial training faculty that would be joining us free of charge.
Great. I am aware that we have 1 minute left, so we do want to highlight, Leslie, the technical assistance materials that are available on the NUAP website and how to contact them, you all. And I think I just said it here, so you can go to the newapp.org. Go VAWA Confidentiality for today's web conference. The phone number 202-274-4457. Always email newapp at wcl.american.edu, and the New App Library at www.newapplibrary.wcl.american.edu. And so there's great resources for this web conference and a whole host of web conferences that we have been offering over the last several years.
David, in conclusion, I can say Jane is an example of one of our partner programs, and so if you are we're partnering under our current grant with Equitas, the prosecutor's resource. So if you call our number, and Jane, maybe you can post your number, or whatever contact, but you can call us, and if it's a prosecutor, we will put you in touch with Jane or one of her colleagues who will help the prosecutor, provide prosecutor-to-prosecutor TA on these issues.
Great. Thank you, Jane, for posting the information that is in the text chat. So this concludes today's web conference. I want to thank all of you for I want to thank Amy and Jane and Leslie for presenting, and Rocio for all of the questions in the back, and for all of you for sharing your information. At the conclusion of this, you will be getting in about a half hour a follow-up, which will have a link to where to get the information. Also a link to an evaluation that's very important for us as we are designing future trainings and giving feedback to us, so we really appreciate you completing the evaluation. That should be coming to you in approximately a half hour. So this will conclude today's session. I want to thank all of you for joining us today, and look forward to seeing you at a future New App web conference or training. Hope you have a good remainder of your day.